Why does the law enforce some promises but not all? If someone promises you a gift out of love or friendship and later changes their mind, the law usually does not help. But when two people exchange something of value, the law becomes concerned and willing to enforce that promise. The reason behind this difference lies in the concept of consideration. This is episode 3 of our Indian Contract Act series, and in this class we learn why consideration is regarded as the heart of every enforceable contract. Section 2 describes consideration as something done or not done or promised to be done by one party in return for a promise made by the other. In simpler words, consideration means each party must give something and get something. It is the idea of mutual benefit. A contract is not charity. It is an exchange. If one party gives something without expecting anything in return, it becomes a mere moral or social obligation, not a legal one. We see consideration everywhere in daily life. When you pay a shopkeeper money and receive goods in return, both sides give and receive something of value. When you work for a company and receive a salary, your service is the consideration for the employer and salary is the consideration for you. Even promises can be consideration when you agree to do something in the future. Without this give and take, the law will not enforce a promise because it does not want to interfere in purely emotional or personal relationships. Consideration may be of three types: something done already in the past which the promiser has benefited from, something being done in the present at the time of agreement, or something to be done in the future. All three are valid under Indian law as long as the act or promise has value and is connected to the agreement. For example, if a friend helped you shift to a new house and later you promised to pay him 1,000 rupees as a token of appreciation, there is value, though past. If you pay instantly while buying food, that is present consideration. When you commit to paying fees in monthly installments for coaching, that is future consideration. Another important rule in India is that consideration may move from the promisee or even from any other person, provided the promiser gets the benefit. For instance, suppose a father pays the fees for his daughter to join a course. The daughter is the one receiving the service, but the father provides the consideration. The contract is still valid because the promiser, the coaching institute, gets its benefit. However, not everything can be treated as valid consideration. It must be real, lawful, and possible to perform. If someone promises to pay money for something illegal, immoral, or impossible, the law does not recognize the deal. Similarly, if someone promises to do something they are already legally bound to do, that may not amount to fresh consideration. Consideration is essential because it shows the seriousness of the promise. It helps the court identify which promises are meant to create legal obligations and which are merely gestures of affection, friendship, or goodwill. When a contract is backed by consideration, it indicates that both parties see value in the relationship and expects the law to protect that value. To summarize the idea through a simple example, if a person tells you, "I will give you a gift next week," and later refuses, the law usually cannot force them because you gave nothing in return. But if the person says, "If you help me with my project, I will pay you," and you help sincerely, the law protects your right to payment because you provided consideration. Therefore, consideration plays the role of a backbone supporting the enforceability of a contract. It is the element that transforms promises from mere words into legal commitments. In the next episode, we will discuss the examiner who is legally competent to enter into an agreement and how the law protects minors and persons of unsound mind. Continue with this journey step by step, and contract law will become clear and logical.